that Supreme Court's draft opinion was real, although it doesn't necessarily represent the final view of the court, just adding in the lawyery language in there as he has to do. But before I get into what the opinion entails, I want to back up to 1973 in Roe v. Wade. So, abortion before Roe was legal in some states, illegal in others, like here in Texas, and then somewhere in between and more. It was a hodgepodge of different states representing the values of their constituents. I think Texas was right, of course, but New York had their own abortion policy, California had theirs, Wyoming had theirs, etc. But then this court case out of Texas in Roe v. Wade, the Supreme Court decided, no, we're going to apply one blanket policy across the board. So what they said was they found a fundamental right to an abortion, that certain parts of the Constitution protect an aspect of privacy. And from those parts of the Constitution, like the 9th Amendment, 14th Amendment, 5th Amendment, etc., they could derive a more general right to privacy, which was an umbrella that protected many other specific rights, like abortion. And so they said abortion was one of these protected rights, not written in the Constitution, but implied by certain provisions, and that therefore, states can actually ban abortion. And the net effect of Roe and its companion case, Doe versus Bolton in 1973, was that abortion through all 9 months was protected, quote unquote, by the United States Constitution. So that means we couldn't ban abortion here in Texas, nor could Alabama or Mississippi or North Dakota or any other conservative pro-life state. 19 years later, in 1992, it looked like we were about to change that. In a case called Planned Parenthood versus Casey, named after Bob Casey, the former pro-life Democratic governor of Pennsylvania, they had passed some pro-life laws, and the case went to the Supreme Court from that state. And there was a Republican-appointed majority on the Supreme Court at the time, and everyone assumed that that case was going to reverse Roe. But that's not what happened. What came out was a 5-4 decision with a 3-justice plurality affirming the essential holding of Roe, or what they call the essential holding of Roe, and then restructuring certain aspects of it. So instead of abortion being a fundamental right, they called it a constitutionally protected liberty interest. And they said before viability, states could restrict or regulate abortion so long as they did not impose what they called an undue burden, which went largely undefined. They provided a synonym, substantial obstacle, but doesn't really give us clarity on what undue burden actually means. And after viability, the state could ban abortion, but with pretty broad health exceptions. So that was Planned Parenthood versus Casey. It didn't strike down Roe like we thought. It just relaxed Roe a little bit, but further cemented the idea of legal abortion further into our culture and laws. There's been some other Supreme Court decisions since then, but none that have directly challenged Roe, like the current case we have right now, Dobbs versus Jackson Women's Health Services. So the law itself actually comes out of Mississippi. In 2019, the state of Mississippi passed a 15-week abortion ban, banning abortion 15 weeks after the woman's last menstrual period. The abortion industry challenged that law, as they challenged almost all pro-life laws, and the district court struck it down. And the Fifth Circuit, which is a very conservative circuit court, we're in the Fifth Circuit as well, it has Texas, Louisiana, and Mississippi, reluctantly upheld the lower court's decision. In fact, one of the justices in that case, Judge James Ho, who's a very stalwart, committed conservative, said, I have no choice but to side with the abortion industry here because of Supreme Court precedent. But Roe is an abomination, and it's time for the Supreme Court to revisit it. The state of Mississippi appealed to the Supreme Court of the United States, but people didn't expect them to take the case because there wasn't a circuit split on this issue. Typically, the Supreme Court will only take a case if it's a question of national importance, so it's a national law that was passed that affects everyone, then the Supreme Court would want to get involved, or if 2 different circuit courts are saying different things. So one circuit court says abortion's at 15 weeks are protected by the Constitution, and another circuit court says abortions at 15 weeks aren't protected by the Constitution. Well, we all know the United States Constitution means the same thing in different states. And so, in the event of that sort of circuit split, the Supreme Court wants to get involved and rectify that discrepancy. But that didn't exist in this case, so no one assumed the court would take it. But weeks went by, months went by, nearly a year went by. The Supreme Court had not said no. They could have just said no already, like we expected them to, but they hadn't said anything. And so there was speculation that there might be votes to take this case, even though there wasn't a circuit split. And then last June, they did. They took the case to the surprise of everyone. And the question they actually took up was whether all pre-viability abortion bans constitute an undue burden. So it was a direct challenge to the Roe and Casey framework. Many people assumed when the court took the case that they wouldn't fully reverse Roe, but like Casey, they would walk the stringency of the requirements back a little bit. It'll make it a little bit easier for states to pass pro-life laws like Mississippi's 15-week abortion ban. But as people thought about it a little bit more, they started thinking, how can the Supreme Court craft a decision that did this, that upheld Mississippi's pro-life law, but stopped short of reversing Roe? There is a great pro-life constitutional scholar out of Notre Dame who made this point, and he said that any sort of decision that the Supreme Court makes is going to have to craft some sort of new standard. Right now it's viability. There'll have to be some sort of new standard before 15 weeks. And any sort of standard that's going to be is either going to be specific, out of like 10 weeks, for instance. But if it's that specific and determinative, it's going to sound made up. Like, where did you get 10 weeks? Where'd that come from? Or it's going to be broad and vague, and so it's a reasonable opportunity to obtain an abortion. But again, okay, maybe that's more constitutional, but what does that even mean? And so you're going to have more and more litigation. That kind of decision is going to invite more and more lawsuits testing those boundaries. And it's going to further cement the Supreme Court's role in abortion. And trust me, they're tired of it. They don't like the politicization abortion brings to the Supreme Court. So either of those two paths weren't going to work. And then others suggested, well, they can just do it on stare decisis, the idea of respecting precedent. And they can just apply Casey and say, under Casey, undue burden actually means this. But that completely redefines what undue burden actually means. Under Casey, it's very explicit that a ban constitutes an undue burden. So this would actually just redefine undue burden completely. And Chief Justice John Roberts actually made the point in a previous case that stare decisis is a doctrine of preservation, not transformation. So you couldn't use the idea of respecting precedent as a way to uphold Mississippi's law, but stopping short of reversing Roe. So all of this analysis came in before oral argument, which was set on December 1st. Then that date came. We listened to the oral argument, which lasted about an hour and a half, and it was very clear. There appeared to be 5 justices, so Clarence Thomas, Samuel Alito, Amy Coney Barrett, Brett Kavanaugh, and Neil Gorsuch, who were willing to reverse Roe. They sounded very skeptical of Roe and very skeptical of the middle ground path that Chief Justice Roberts was trying to forge. So out of oral argument, a lot of the analysis was like, wow, they may actually reverse Roe. Those initial predictions we had about the summer that they'd stop short don't appear to be the case. But like with everything the Supreme Court does, it's done in secret. They go behind closed doors, they deliberate, and they start crafting their decisions. So until they actually release the decision, we may have 1 or 2 hits, like soft leaks coming out of the court, but that's all we'll know because it's all behind closed doors. But early May comes around. Not only do we get a leak about where the justices are, we get the whole friggin' draft opinion, all 60 pages plus 30 pages of appendices, right there for all of us to read. And it was a brilliant, thorough rebuttal of Roe v. Wade, fully reversing the decision and sending it to the ash heap of history where it belongs. So wow, we usually don't know the outcome of the game until the bottom of the ninth inning when all 3 outs are made. Now we know in the 7th inning we have it. We're up 10-2. How could we blow this? Well, of course, the decision is not final. In 1992, in Planned Parenthood versus Casey, yes, we thought it would go our way, but rumor has it, in deliberations, it was going our way. And that it was actually a liberal scholar, Larry Tribe from Harvard, who convinced Justice Kennedy to flip and to uphold Roe. If y'all remember in the Obamacare case in 2012, Chief Justice John Roberts was a vote to strike down the individual mandate. And then sometime around April, he flipped his vote and created that understanding of the mandate as a tax rather than a penalty to uphold it. Even though at one point he was going to vote with the other conservatives and strike it down. So votes flip often in deliberations. Justices are trying to convince each other. And some, Chief Justice Roberts most notoriously, buckle to public pressure. And even more recently, I think it was last year, a case challenging Employment Division v. Smith, which is actually a very terrible decision on religious liberty. Sadly, it was authored by Justice Scalia, and I have reason to believe he later thought of that decision as trash. It's very bad, and I think he later regretted that. And it looked like Alito wrote the majority opinion to strike down Employment Division v. Smith, which is good, because it limits our constitutionally protected religious interests in the First Amendment. But that came out as a concurrence, and people thought that concurrence looked awfully like an actual majority opinion. So it's possible votes flipped there as well. So it happens, and that's actually probably why this decision was leaked. It was an opportunity for the public to pressure the justices. We've seen a bunch of rabid progressives going outside the conservatives' home, trying to intimidate them and intimidate their families. Listen, if you want to protest outside the Supreme Court, that's your constitutional right. When the justices are at the Supreme Court, they're Supreme Court justices. They're constitutional officers. And therefore, they answer to us in a kind of narrow, indirect way. But when they're home, their fathers, their mothers, their husbands and wives, their neighbors, you should not be going outside of people's homes to intimidate them, to try to pressure them into changing their decision. That's not how we do justice in this country. But that's probably why it was leaked. We still don't know the leaker at this time, but one can assume it was an effort to actually pressure the justices or to apply galvanized public pressure and to maybe getting Kavanaugh or Barrett or someone to flip to the other side and join Chief Justice Roberts in that middle ground road that would uphold Mississippi's law but stop short of reversing Roe. I think it may backfire in the sense that it's probably going to cement and harden the justices wherever they are right now, which would be positive because last we know, and some of the leaks say that there were still, as of 2 weeks ago, 5 votes to reverse Roe v. Wade. So let's talk about the actual decision itself. So the draft opinion, so not a decision, it's not a decision yet, this is a draft opinion, I don't want to jinx it. It fully reverses Roe. And the way Alito goes about this opinion is in 2 parts. First, he looks at the substance of Roe itself. Was Roe correct in determining that abortion was a constitutional right? And 2, even if Roe was incorrect, are they stare decisis factors that mean we should still uphold it even if it was wrong? And I'll get to that in a sec. But starting from the top, was Roe correctly decided? Well, we know for a fact that abortion is not an enumerated right. The word abortion or anything close to it does not show up in the Constitution. It's not in the Bill of Rights. So it's an unenumerated right, meaning it's unwritten. Now, the idea of unenumerated rights It's pretty simple. The way the Constitution is structured and the way our government is structured is not one that grants rights. It's one that recognizes rights that come from our Creator. That's the purpose of our government. Rights come from God, not from man. And that means if it's not explicitly written in the Constitution, that does not mean it's not a right. In fact, the Federalists at the time of the Constitution's drafting were afraid of a Bill of Rights because they thought that if you actually write certain rights down on paper, that people will assume rights are limited to those rights that are written down on paper. And that's not the case, that our rights are more expansive than the ones that show up in the Bill of Rights. For instance, it does not say in the United States Constitution that the government can't force you to go buy their groceries on the weekend. So the Texas legislature, if that was the case, could say, we're gonna pick X number of citizens at random each week to go buy our groceries. But that would be ruled unconstitutional, and rightly so, because there's an unenumerated historical right to travel. And the government can't impose that sort of travel on you. But how do you identify what rights are unenumerated? That's the key, because that can be heavily abused to favor your politics and your understanding of rights. And that's historically what some justices have done, most famously in the Warren Court in the 1960s. Well, they just started inventing constitutional rights left and right that mirrored their own personal politics. So Alito goes and looks at a case called Washington versus Luxburg, which was a case out of the state of Washington related to assisted suicide. And in the Supreme Court in that case determined that assisted suicide was not a constitutional right. And it says, when identifying an enumerated right, you have to look at the nation's text and history and tradition. So if you try to identify a historical right, you can look at whether it's enumerated or not, or if it's widely been considered a right, even though it's not been written down. So the right to travel between states, for instance, has largely and widely been understood to be a right. The right to own a dog, for instance, has been understood to be a right. That's never been challenged. But abortion's different, because historically abortion has been criminalized and not considered, at least, not lawful. So after quickening, which is the point in pregnancy in which a mother can feel her child move, abortion was criminalized, it was illegal. But before then, it was considered a precondition, at least, to murder statutes, certain homicide statutes. So murder involves intention, but if you also murder someone or kill someone in the process of committing an otherwise illegal act, that would also be considered murder, even if you didn't intend their death. That still holds true today. Back in the colonial times, if a doctor was committing an abortion on a pre-quickened child and killed the mother in the process, that can be considered murder, not just manslaughter, because he was committing an abortion that was considered illegal. So that's sort of the historical backdrop. And by the time of the 14th Amendment, over 40 states had banned abortion from fertilization. So it was very clear based on this history that abortion was never considered a constitutional right. That in fact, for the most part, people opposed abortion. And for that reason, abortion was not a historical right and therefore is not protected by the Constitution in any sense. And therefore, Roe v. Wade is wrong. Then you move on to part 2, which is the stare decisis analysis. And there's different aspects you look at. Whether the first decision was just wrong or egregiously wrong. Spoiler alert, it's egregiously wrong, and he said that. He also looked at, for instance, reliance interests. So if people have come to rely on this over an extended period of time, well, removing this right unduly harmed them. So you look at these different factors and determining whether abortion should be protected under stare decisis, and he said no, that for good reason, some people might support abortion, but does not make it a right. And that some people have relied on it at certain points in time, but it's not a concrete interest in the sense that, for instance, gay marriage, let's use that as an example. At any point in time, if the Supreme Court undid Hellerstedt, the 2015 decision protecting gay marriage under the Constitution, that would potentially nullify all of these gay marriages and all of their rights that they have under their gay marriage. That's going to upend their lives to an extreme amount. But abortion's different in that you can simply choose not to have an abortion at any time. The reliance interest isn't as concrete. And so for that reason and others, there's no good reason to uphold Roe even though it was wrong. And so that's essentially the opinion, fully striking down Roe. And what it does is it just returns abortion to the states and allows states to set their own policy. And I'm going to talk about what Texas will look like in a post-Roe world in a sec. But there were some criticisms, of course, of this draft opinion. The first, which was kind of curious, was that this actually attacks other constitutional rights like gay marriage or interracial marriage, which that's odd. The idea that that Justice Thomas wants to undermine his own marriage to a white woman is odd. I guarantee you Justice Thomas supports interracial marriage because he's a black man married to a white woman. So that's a very odd criticism. But the idea was he was attacking these substantive due process rights, these unenumerated rights, and that they have to be rooted in our nation's tax histories and traditions. But gay marriage isn't rooted in this. It's kind of going in out.
No, you got something.
Got it? Cool. So gay marriage isn't rooted in our nation's tax history and tradition. So this decision seems to attack these other unenumerated rights. But Alito distinguishes abortion from these other rights in two ways. The first is that abortion as an act is different than gay marriage. So gay marriage is two consenting adults coming together to make a decision. Abortion involves one party who's not consenting to the act, that is a preborn child. That's fundamentally different than these other acts. So even if you take this maximalist, libertarian-esque understanding of unenumerated rights, where anything that's consented to is a right, abortion does not count, because it's a completely different act in which a preborn child does not consent to being killed. So it's not like these other acts like sodomy or contraception or gay marriage or interracial marriage. Those are the big cases they brought up as objections. The other way you can distinguish it is the reliance interest aspect part. So people rely a whole lot more, gay couples rely a whole lot more on the right to gay marriage than any pregnant mother relies on the right to an abortion. The solution to the Supreme Court getting rid of Roe v. Wade is, in a state like Texas, is to simply not have an abortion. But if they got rid of Hellerstedt, the solution for many gay couples would be, okay, your whole life has been upended. You're in the process of adopting this kid. Now, whether we think that's right or wrong, that was speaking from a reality-based factual perspective here. That would have to go away. All of these tax benefits that you've relied on, the way you organize your income, all that will have to change. And so there's more concrete reliance interests in these other rights than there are with abortion. So for that reason, us reversing Roe is not us attacking these other unenumerated rights. So I think that criticism fails. Another criticism is when Alito underwent this text history tradition analysis, he considered abortion a very specific right. But then they said, no, we need to consider it as a broader right, like the right to bodily integrity. But the problem with that is, and Alito noted this, is that it's a pretty capacious, abstract right. The larger you get, the harder it is to define. And so even if you consider bodily integrity, certainly some supporters of abortion would say, like, yeah, abortion, like restricting abortion is a violation of bodily integrity. But pro-lifers will respond, yeah, I agree with you that abortion is a violation of someone's bodily integrity, but it's the child's bodily integrity. So even if this understanding of bodily integrity, even if you just go from the historical understanding of bodily integrity, that doesn't necessarily implicate abortion as some sort of constitutional right. So I think that criticism fails as well. And the third is that, well, Amy Coney Barrett and Brett Kavanaugh and Neil Gorsuch are just liars. They say they uphold Roe, that Roe was final, and that it wasn't going anywhere, but now they're voting to get rid of it. Well, okay, we're not barred by those statements. They can do what they want when they're on the court. But the second is they never said that. They said abortion was precedent, or Roe v. Wade was precedent, which was true. Abortion was the law under the Supreme Court while they were getting appointed to the court. And they acknowledged that. That doesn't mean it's unassailable. That doesn't mean they can't themselves, as a justice, go after it or rule against it or reverse it. It just means they were acknowledging the facts on the ground. So I think that's just crying and whimpering a little bit on the side of the abortion industry and abortion supporters. But those are the three main criticisms. I think they all fail. If anything, the only thing I think that might change in the new decision, that's most likely to change, is you'll see Alito respond to some criticism of the liberal justice's dissent, but he might tone down the language a little bit. It's very, like, as a pro-lifer, I loved it. I thought it was fantastic. Like, Alito, you're my spirit animal here. Exactly what I want you to write. But maybe it's not the most persuasive to someone who's right in the middle, who's not sure if abortion's a constitutional right. So you might tone down the language just a little bit, but that doesn't change the actual substance of the decision. When do I think the decision will actually come down now? Well, we don't know. Some have said the Supreme Court, they can't really ask them, but have suggested the Supreme Court should release it quickly. But as of a couple weeks ago, we know it was the only draft in Dobbs that was circulated. Now I don't suspect, well, there are going to be leaks, certainly, right? Well, probably not anymore, because I imagine the justices aren't even going to be sharing anything on Dobbs with the clerks. Like this process is just going to be between 9 justices now. So the source, the original leaker, and other leakers as well that have followed, which there have been some conservative leakers who have said that 5 justice majority is still in place. Anymore. The Supreme Court justices are going to shut that down. So we're not going to get any information anymore. So the most likely outcome is the status quo is going to prevail, and it'll be a decision towards the end of June, early July, maybe the week of RPT. We'll see. I think that'd be fun, actually. But it'll be towards the end of the term, which has historically been the case, and was what we expected before the leak actually occurred. So that's Dobbs, and now let's talk about Texas. So if Dobbs does reverse Roe, and that's what we expect at this point, that's what we're praying for, we'll see. We can't celebrate yet, it would not be smart. That would have been a mistake in some cases, like Obamacare, Planned Parenthood versus Casey. But if Dobbs does reverse Roe, in Texas, abortion will be banned from fertilization. And there are 2 reasons for that. First is last session, the Texas legislature passed a trigger ban on abortion that goes into effect when Roe versus Wade is reversed. So that means the Supreme Court does that, set a number of weeks later, trigger will go into effect and we'll have a ban on abortions from fertilization. The second reason is we have actually pre-Roe statutes that have never been repealed by the Texas legislature that ban abortions. Those will become enforceable once again. So we actually have 2 different mechanisms to ban abortion from fertilization once Roe versus Wade is reversed. So that's great. We'll have pro-life protections for preborn babies from fertilization to the end of pregnancy. But the challenge doesn't stop there. And that's because the abortion industry has made it very clear they're not going to comply with the law in any sort of informal manner. So yes, they may shutter their big clinics that we see above the ground, but they're working on establishing an operation below ground where they can distribute abortion pills to pregnant mothers that they can take without the government ever knowing. Simultaneously, DAs around the country, including in Texas have made clear that they won't enforce any pro-life laws. So that means we have to ensure that even the above ground abortion industry, like the mega clinic, mega Planned Parenthood facility at 45, aren't able to operate freely because Kim Ogg has decided she's not going to prosecute abortionists. There's two ways to do that. First is we can model civil enforcement after the Heartbeat Act, which is empowering pro-life citizens like you and me to sue abortionists who violate the law. And we can also empower district attorneys from red parts of the state, like Smith County, where Tyler is, to come in to other jurisdictions that are blue, like Harris County, or Travis County, or Dallas County, and hopefully Harris County is not blue for forever. We're working to change that. But we can empower those district attorneys to go into these blue jurisdictions and enforce state law there. And basically, like, we don't care what you're gonna do, Kim Ogg. We don't care what you're gonna do, Travis County DA. The Smith County DA is gonna prosecute these abortionists. So that's that step. And then as far as stopping the below ground abortion industry, where we have abortion pills being shipped in from overseas websites and overseas clinics, that's going to be very difficult because it's happening under our eyes where we can't see it. Especially early in pregnancy, we may never know a pregnant mother was pregnant. And even if she was, even if we did know, how are we going to go after these abortionists when they're prescribing these pills from the Netherlands or from India? How are we going to be able to go after them? So these are very vexing questions for the pro-life movement to deal with, even in Texas. And of course, even if you're able to stop that as well, there's nothing that's stopping pregnant mothers from going to other states like California, New York, Illinois to obtain an abortion there. So it's really a pretty state effort to ban abortion as well. So those are challenges ahead for the pro-life movement. Legally, culturally, we have to continue to build a pro-life state and a pro-life nation. Because as I said earlier, any sort of pro-life victories we obtain in legislature now will not be enduring victories if there's not a corresponding change in the culture. Ultimately, we live in a quasi-democracy. It's a republic. There are some, it's not strictly majoritarian, there are some protections for minority. But if the majority of people support abortion adamantly, any sort of pro-life laws you pass aren't going to last because eventually politicians will adapt their politics to reflect voters. So we have to change the culture as well. That's why Texas Right to Life has an education department, so we can actually be on the battlegrounds of culture on college campuses. It's why we're going to support certain laws to really bolster programs like the Alternatives to Abortion program, which supports mothers, babies, and their families. That's going to be critical going forward as well, is we're going to have to respond with compassion and with action moving forward. And not just banning abortion, not just stopping abortions, but building a pro-life culture as well. So that's a task ahead. Dobbs is out of our control. It looks good, but
A low-income person with, let's say, their fifth pregnancy, where it would be an economic hardship, would those be probably where they'd be vulnerable?
so he actually addresses this. And one of the reasons why he says the reliance interests aren't as strong in abortion is because we have things like safe haven laws, for instance. You're right, I don't think abortion is permissible even if the woman doesn't have another option. However, there are other options in society, including dropping off a baby at a fire department and leaving. 100% legal in every state of Texas. So it's not, you cannot plausibly argue that because I can't afford to raise this child, I have to obtain an abortion. That's a logical fallacy because we have other options that are available to everyone. And he addresses that in his majority opinion, and that was actually a point brought up by Justice Amy Coney Barrett in an oral argument that the existence, for instance, of these safe haven laws means the reliance interests aren't as strong.
The other question I have, of course, you relating it to Texas, but it really kind of applies to all the states, and that basically abortion, the biggest factor in it is government funding. There's billions of dollars every year that are spent in that, and that would definitely, if they stop the government funding because of the reversal, would definitely change that. And that would have a major impact on it. Now, as you said, there's, above ground and below ground. But my daughter's a district attorney, so I understand. But there's virtually no prosecution going on in that arena
Right.
on an above board basis
Oh,
currently,
yeah.
particularly in Harris County.
It's a mess, yes. And so, what we like with pro-life laws, or with any law, it's good to have not just one enforcement mechanism, but three: the criminal aspect, the civil aspect, and the administrative aspect. Which is why, for instance, one thing we're going to be promoting is applying the civil enforcement of the Texas Heartbeat Act, which has scared the abortion industry into submission. We want to apply that to all of our pro-life laws. So we think that's a way to work around the sort of the backlog in our criminal justice system, which it's a mess that needs to be fixed separately, and I hope that's something the legislature prioritizes next session. As far as the actual funding part, you're absolutely right. The Hyde Amendment, a federal budget rider that prohibits the funding of abortions with rape and incest exceptions, has been estimated to save 1 million lives since it went into effect shortly after Roe. And we know the abortion industry still receives direct funding in subsidized abortion states and receives indirect funding in every state through Medicaid, and Title X funding as well. So that might be something to work on at the federal level, is stopping that sort of funding going to Planned Parenthood and other abortion providers. I don't know if a federal abortion ban is tenable. I'm not 100% sure if it's constitutional or not. I think it would be worth trying, but it's unlikely to have the sort of majority needed to pass it. One thing we can definitely do at the federal level is go after that funding. We've already done that here in Texas, by the way.
Any other questions? Good question. Here we
Yes.
go, one right here.
Do you feel that this so-called meeting of the Supreme Court was planned so that it could maybe present an opportunity for people to bring pressure upon the judges?
I think that's likely. There have been different theories, but I think the most plausible one is that this draft was circulated in February, and a lot of these activist clerks who clerk for leftist judges on the court obviously were heartbroken at first and cried themselves to sleep at night for weeks on end, thinking maybe this will change. May hits, it does not change. The votes are still in place, like, wow, this is the last shot, we have to do something. I care about abortion more than I do my law career. I care about it more than I do future employment opportunities. Therefore, I'm going to go ahead and leak this opinion to a reporter, and hopefully that will galvanize the public to go pressure these justices and they'll shy away. I think that's the most plausible explanation. Another one is simply that they just want to watch the world burn. Like, screw this place. This is an institution of evil. Abortions is positive good. They're getting rid of that right. This is an evil place. I want to burn it down. That's another explanation as well.
Any other question? Go ahead.
Related to that, when we saw the December 1st arguments, it appeared that things were going to go our way. So it should not have been a surprise to the other side that it could go that way. So when I see somebody like Elizabeth Warren angry and shocked, I'm thinking that's put on because they already knew that was coming. So did they, I think related to his question, did they plan ahead of time, if it comes out this way, this is the timing and this is what we'll do? Could it have been that conspiratorial?
I suspect it was a clerk or clerks. It could have been maybe a clerk with the permission of a justice, depending on the justice. There are 3 liberal justices on the court. Samuel Alito, he's great. Stephen Breyer, who's retiring at the end of this term. Elena Kagan. Eventually, they will say, this is an opinion day and the last opinion day of the term. They've not gotten to that point yet. There's an opinion day on Monday. Dobbs could come out. I highly doubt it. But historically, they go on recess late June, early July, but we don't know the exact day until they tell us this is the last day.
Any other questions, sir?
Prosecutorial discretion gives me a lot of angst.
Yes.
That's the push, if you will, to elect liberal district attorneys like we have. Couple that with the court's ruling against the Attorney General in dealing with illegal immigration. So you set up with a system where only the local district attorneys are the prosecutors. There's no overarching prosecutor in the state other than the local district attorney, unless there are certain special things. You gave me a little bit of hope in the fact that a prosecutor, say from Tyler, could prosecute an issue. Can you blow that up a little bit more for me? Because my mind is real siloed around counties and prosecutors.
Yeah, so that's not something that currently exists, but it's an idea that's being floated. Representative Briscoe Kane, who represents part of Eastern Harris County, floated that idea, and we think that could work. And it might be a good idea to expand that beyond abortion, by the way, with the state of prosecution in many blue jurisdictions like Houston. But it's an idea that's being floated along with civil enforcement, so it's not there yet. But we're going to explore those ideas next session. So we still have a lot of work to do, and enforcement is going to be a key aspect. Empowering the Attorney General to do stuff too could be part of that as well.
But if the government switch, it could be the noose that hangs you too, you know?
Oh, yes. So which was why we need good state laws. I could probably come through all of Texas statutes and find like this is a dumb law that some blue district attorney is going to use to go after conservatives. Which is why we need good elected officials who will spot the bad law and change it. So if y'all want to, like before next session, just go read every part of law and identify the dumb parts and come up with bill ideas. Do that as well because that's needed.
Do you think we'll ever find the leaker?
Well, here's something. So if you look at the actual document itself, it was clearly scanned. You can look at it and see it's offset a little bit. So it was not the actual PDF that was sent directly to the reporter. It was scanned and I guess faxed over, which means this person was very careful not leaving that electronic trace. So the key is going to be they cannot lie to the court marshal who's investigating this. That you cannot lie to a federal officer investigating a crime. And the court marshal is considered a federal investigator or officer. If you lie to them, you can be punished for lying, even if your act was not illegal. So many have come to the conclusion that the leak itself isn't illegal. But if you're being questioned by a federal officer and you lie about the leak, even though the underlying act was illegal, your lying is, and you can be prosecuted for lying. So whoever this leaker is going to have to make a decision. How well did I cover my tracks? Did I cover my tracks perfectly? Is it going to be impossible for them to decide, determine it was me? If so, I'm going to lie, knowing I got away with it. If I think there's the slightest chance that I made a mistake in leaking this, that it's not foolproof, I don't want to lie and go to jail for lying. I'll just admit to leaking it, and then maybe people hate me, but then I want to get a primetime show on MSNBC. So that's maybe how we'll discover whoever this is they determine it's probably best to tell the truth to the court martial in their investigation because they don't want to risk lying and committing a federal crime that way.
Any other questions? Yes, ma'am.
Yes, regarding the leak, when I heard it, I thought everybody should be fired. And if everybody gets fired, how long would it take for the court to go back into business? Because they're talking all the clerks, everybody go away.
Yes, that's a good question. So someone, a lawyer I follow on a podcast said, you don't know who the clerk is, hire all of them. All of them, we're not going to kind of dismiss them. We don't want to reprimand them in a way that can harm their resume, because we don't want to harm innocent people. But we can't trust them. We don't know who did this. Let's dismiss all of them. Some Supreme Court justices rely a whole lot more on their clerks than others. Samuel Alito famously does not. He basically is able to do everything without his clerks. It's possible you can ask the justices, like, yes, you're gonna have to put in 90-hour weeks until the end of the term, but so what? Y'all are all rich and you're about to go on recess and vacation anyway. Whatever. And then the new batch of clerks comes in for next term. It would involve a lot of work, but it's not impossible that they haven't done that already. Proportional response, but it hasn't happened yet, so probably.
Thank you.
Any other questions? Let's go to Jacksonville.
Can I ask one more question?
Yes.
So, about the way the Texas Harvey law is set up for citizens to do stuff, we're looking here, what can we do? So, does it relate to that? Are there other things we can do as
So,
well?
yeah, the Texas Heartbeat Act is still in effect, still saving lives. Now, with the reversal of Roe, what will happen is the Texas Heartbeat Act will kind of be null and void at that point, because we'll have a stronger law in effect, which is good news. It means that the Texas Heartbeat Act was able to bridge us from last September until now, saving tens of thousands of lives who would otherwise been lost to abortion, which is fantastic. But in the meantime, what can y'all do? If y'all know of anything, reach out to us, let us know. We're pretty sure the abortion industry is complying, or at least mostly complying with the law. We see that with the reports coming out of the Health and Human Services Commission. So the best thing you can do is be mindful and let us know if you see anything.
I did have So, you had talked about action and compassion. And so, is the Texas Right to Life thinking of things like, okay, we spend millions to fund abortion, right? But what about helping fund birth control? Because basically, abortion is being used as birth control.
Yes, by some people, for sure.
Yes. Could it be helpful, and what is Texas Right to Life thinking about as the compassion of, instead of just saying, okay, now you're cut off, but to educate and also to provide means of birth control that are usable and plausible to the people who have been using abortion as birth control.
So the Texas legislature already does fund birth control through the Healthy Texas Women Program, which is funded at like hundreds of millions of dollars per year. And every year there are amendments to expand that funding. I imagine that program is going to be one of the ones that is prioritized in the post-Roe world. We don't personally, as an organization, take a stance on birth control, but we do support the Healthy Texas Women Program as a government program in the state of Texas. So we do agree that it's not just enough to ban abortion. We must support pregnant mothers so they don't need abortion, so they don't become unexpectedly pregnant, or if they do, they have the resources they need to be able to thrive, flourish without abortion. Great, thank you.
Thank you, sir.